Bava Metzia DAF Chaf, sponsored for Refuah Shalema for Daniel David ben Menucha. The law concerning one who finds a receipt for a ksuba. A brisa states that if the wife agrees that her ksuba was paid, the finder can return the receipt to the husband. The Gemara explains there is no concern that she wrote the receipt in Nisan but did not receive payment until Tishrei. If she sold her rights to the ksuba between that time, the husband can use the predated receipt to collect from the purchaser illegally. Rava answers, the brisa follows the opinion of Shmuel. One can forgo a debt even after selling its rights to another. Although the Chachamim allowed one to transfer the rights to collect the debt, the creditor remains the sole owner of the debt and the right to forego it, since he transferred a right, not something tangible. Therefore, in our case, the wife does not have to resort to a fraud. She can simply forgo the ksuba debt. Therefore, we return it to the husband if she agrees. Abaya disagrees. He says our case is where the court knows she is in possession of her ksuba. Otherwise, they would not return it to the husband for fear of fraud. However, Abaya adds that the finder may return it even if the court does not know that she's in possession, because the witnesses to the receipt in Nisan acquire it for the husband. Mitam zachin la'adam shelo b'fanav. His wife has no right to sell, even if she did not receive her ksuba until later. A new Mishnah. Documents found that may be returned. Number one is an igros shum, a court-written document for the creditor to seize property from his debtor. It is returned to the creditor. Second is an igros mazon, a document proving commitment for a stepdaughter's sustenance. It can be returned to her. Number three are shtare, chalitza, and miyun that were found. Court-written documents proving Yavama underwent chalitza or an annulment of rabbinic marriage of a katana, and then both can remarry. These prove that even in respect to Isur, the court can be lenient to return lost documents. Number four is shtare beirurin. A court stenographer records claims of litigants, so they can't retract. Rabbi Yirmiyah explains it as a record of the judges each litigant chooses. Number five, a Maisa Besdin. These are court certifications, warrants, and documents of seizure. They can be returned. Why? Number one, courts do not draw up documents in advance. Secondly, a debtor is responsible to maintain proper records of repayment. Now, what about private documents identified by way of a siman and can be returned to the loser? Number one, if the loser can identify the container or the amount bundled together, the Gemara suggests perhaps the identifying characteristics may be how they are rolled together, not particularly the knot. Rav Shimon Gamliel holds that if three are bundled loans for one debtor, it is returned to him. If three are bundled as three loans for a creditor, it is returned to him. A third party who found the loan document bundled together with his documents, not knowing if he received it from the creditor or debtor, the law is it stays with the court until it can be proven who it belongs to. Conditions to determine whether a receipt for a loan in the lender's possession was paid or not paid. Number one, the Mishnah states that a lender who found unissued receipts among his documents should assume the loan was paid. The Gemara explains it refers to where he found it among discarded documents. Number two, Rabbi Yirmiyah bar Abba states that if it was found in the possession of the lender among his regular documents, he can assume that it is unpaid. He wrote it to have it ready in case the borrower comes to pay at a time when he is unable to write it. Number three, if witnesses signed on a receipt testify to the repayment, even if it is in his possession, he cannot collect the debt. Number four, a certified receipt, one with a handpick, meaning judges verified the signatures of the witnesses, also he must assume it is paid. Number five, the lender gave the receipt to a third party to give it to the borrower after payment of the loan. He is trusted to say as that it was paid as well. Number 6, a receipt was written under the signatures of the loan document. It is assumed to be paid. The lender would not have offered his document under any other circumstance.